out solution with the number of people and the people at the table. And I would suggest that we request an ad hoc committee from the city council and Parks and Recs to develop and design a solution for this. Otherwise, we might end up in the same situation that you found yourself with programs.
Well, based on the fact that Council Member Holstage said she was expecting from us a recommendation that would stop the behaviors that we've had at Ruth Hardy Park. I'm not sure that, based on the fact that I think they have 60 subcommissions, standing meetings that at least from what I've pulled out of their directory 3 months ago. That scares me only because I wouldn't want to push something off because they're just not available. We could certainly try that. I'm open to it, but I was actually hoping maybe something stronger than temporary conversion.
Possible 2 new courts being built and
Well,
Duluth.
What I'd like to hear is what the costs are, because if we're talking about $1 million, then let's back off and get temporary nets. But if
That'd be
we're
your
talking,
Taj Mahal. After our last meeting, I started doing some research and calling a few of the vendors around town, and it's kind of ironic. The first gentleman I talked to did court construction, and has explained to him what I was looking for, that the fact we have, tennis courts, and the concept would be either we take and convert those tennis courts, or we build new pickleball courts and leave the tennis courts as tennis courts. And probably in less than 5 minutes in conversation with the guy, he says, you're going to take a tennis court and you're going to drill holes in the concrete to put nets in. And I said, yeah, that's the concept. That's what we did before. He goes, I don't want to be a part of it. I don't want to be involved if you're going to damage the tennis courts. Okay. So on to the next vendor. Someone I'd worked with before, he actually did the court conversions for us. His recommendation is not to build tennis courts, but to build actual new pickleball courts, was his recommendation. So the cost to build 4 pickleball courts, and I didn't do it with lighting, just the courts with fencing, was $50,000. If we wanted to build 8, you're looking at $100,000.
Is that, and shade, it wasn't even enough, that was just the courts.
Just the courts, but I didn't talk about shade or anything at that point, because I don't know if they would do the shade. We'd have to go to somebody else for shade. And does the shade mean we're going to have shaded area where we'd have benches, bleachers? We just put shade over the bleachers to provide that for the participants. And even to the point of not just Duluth, but maybe we add pickleball courts somewhere in some location at Ruth Hardy Park. That way, those who live in that neighborhood still have access to be able to go and play pickleball if they don't want to travel to Duluth. Just the same as we kept the 2 tennis courts. If one wanted to play tennis, they could go to Duluth and play tennis. So that's kind of the numbers I had. I think Councilmember Holsteg was kind of looking at something like that. So what is the magical number? Is it 200,000? We're going to put in maybe 12 pickleball courts. We could put 8 at Duluth and maybe 4 at Ruth Hardy. Is there going to be some angst if we don't put as many at Ruth Hardy as we do at Duluth? I don't know, but at least it would give those that live in that neighborhood 4 courts to play on. So I guess it'd be up to your decision in what direction you'd like to go, and maybe make a recommendation that City Council look at.
So,
So
should we believe that City Council will budget this?
That was my question.
That's the feeling I got from talking with Christy, was that she was going to support
And
this.
timeline for that?
Would depend on how quickly they would want to
So then
allocate the
maybe,
funding.
the recommendation really is that the subcommittee of Parks and Recs meet with the pickleball community and come back with a proposed solution.
when I tell you again, I can't undo what council has done, but I brought a page, and I don't have it right here, but there was a $50,000 increase to budget for
Staff.
an individual to man the courts. at
Right,
Duluth
actually, there was
Park.
$100,000 increase allocated to, and I started working on that today as a RFP to look at basically someone to monitor the tennis courts and pickleball courts. First priority being that Palm Springs residents have priority use of the courts during season, when it's being monitored. And I'm going to be starting working on that, probably trying to put it together and try to get it to a budget ad hoc committee, hopefully by the end of this month, so they can review if that's what they want in it. If there's something missing, we can, put that together, so.
My thought would be, Ruth Hardy Park has always taken care of itself very effectively, and the Muth Park pickleball people they have an entire process for getting on, and there's sort of a rules thing that they do. It's very, very organized. So my thought would be, if there's $100,000 without benefits, and that we would say, wow, that would solve part of our problem right here. I have been looking at this for 2 years, and would love to have separate tennis courts and convert, only because I've heard from all parties who are involved, which are pickleball and tennis people, that they'd like to be a little bit removed from each other. They don't want to be elbow to elbow because there's just a different style there. So it seemed to me that you got 4 tennis courts. If you could convert those and build 2 new courts, it really could work.
So, and I had said last month that, maybe we just really look at a pickleball center. And so, and knowing city government, it will take 6 months or more to get a pickleball center, or to get that 100,000 or 150,000 actually established and spent and up and running. And so it really, I appreciate that. Like we had said, our immediate solution is not a final solution, but it is something that can accommodate all of the players in the morning. And so I love that, and I do think the city council is getting new sources of revenue, and opportunities should be increased. This is a great place and a great way to spend the extra money that they have. And I still think we should meet with pickleball to map out where in the parks and what that could look like and how many courts, and come back and make a more solid recommendation.
Go ahead, Ellen.
Yes.
Was there a reason he gave that he thought it was better to build 4 new pickleball than to convert the 2?
He didn't, but I think the fact of, I think there's sometimes if you look at the courts, there's some difficulty when you actually, and maybe this is why the gentleman had difficulty with us digging into the courts to put the post in for the nets, is that those areas seem to have a tendency to start, having some problems with
Grading.
But if we're not converting back and forth, I can see a big thing of keeping them separate for noise, for camaraderie and all that, and that's why I didn't know whether that was a major problem to do that or not.
He didn't really say. He just said his preference would recommend to be probably easier to build the pickleball courts from ground up than even though obviously it's more costly than converting. But then again, if you're going to build new tennis
Shade
courts,
there.
are they going to be lighted, and that increases your cost? You're going to have higher fences, which increase your cost. So, now your tennis court may cost you
More than a
More money.
pickleball.
Well, one of the things that I did hear in all the times that I went to pickleball is, like tennis, there's a community. With pickleball, there's a community. So I was hearing we would like to be able to have sanctioned and unsanctioned competitions. And today, we have just 8 pickleball courts, and we do a little taping and renting the court to get an additional, so they get to 12 courts. But it kind of concerns me that, and I apologize, that they all be together in one community, that if you start to split them up to multiple parks, then they can't really accomplish their competitive thing that is really a part of what they're attempting to do as a community. Not that we have to be the resource that Indian Wells will be with, 40 courts or whatever, but it tends to be a community thing. If I drive by there at 6 o'clock at night, I see sometimes 40 or 50 players playing and people waiting to play even at night. If I go by at 8 o'clock in the morning, it's the same thing. There's a community there. So I don't know. I would say the subcommittee should look with would it satisfy to be separate? I kind of am liking your idea now of hard striping, and although I can't imagine, I'm not a tennis player and I'm not a pickleball player, but all those lines,
Like-
if you were able to do 4 to a single, maybe a little confusing, but,
Would be.
right, and
It's a very competitive tennis community.
yeah, Ruth Hardy, yeah. I'm open.
I had shared with my ad hoc committee, I played many sports growing up, and if you're on a court in a gym, it's not just lined for basketball, it's not just lined for volleyball, there's a whole bunch of lines on that court, and you have to adapt and learn where your lines are and do the,
Can I ask a question?
Do with that,
Is my memory correct that there is a court at Demuth that is a tennis court that is also lined for, I believe it's.
Pickleball.
Oh,
The
I'd heard
Far
it was
East court
badminton.
has overlay.
Is badminton,
badminton would be
No.
another,
oh, it is
Set of
pickleball.
lines,
yes.
So there's a single painted court for pickleball on a
On
tennis
tennis
court,
court, yes.
which would have to be obliterated if you were to come back and do
put 4.
4 and 4.
Right.
And my only thought is if there is a way to try to ease the issue and get something on those courts quickly so that they can be used for both. And again, as if a tennis player shows up, pickleball gets off, and they bring in their nets, what do you call them? Not permanent, but the standards and stuff. And while the city council takes this process that they will take of whatever our recommendation is for building new courts, permanent courts, because we know that will take a long time, and as we know, they're looking for a more rapid, at least fix for now.
So we all know that pickleball's not going away. So, I think that we should do something with the courts over at Demuth. What we can do, convert them over, get at least that one,
That
not the
done.
east one, but the one in the middle, convert that over to 4 courts. That's gonna take the pressure off of Ruth Hardy Park. The community is strong. I've spoken to over 20 of them, and they're very comfortable, but we gotta move this forward. We gotta just make a move, and then bring it to the city council and take it to the other direction. I'd love to see a Little Valley, There's
Can
one
it-
and there's one in Mesquite, or Cedar City, one of them cities, and it's amazing.
St. George.
St. George. So it's an idea.
Well, I think, if I may, and I want to go back to something that has been said time and time again, and I mean, with a master plan, pickleball would never have been on it because 7 years ago, pickleball didn't have the volume and the velocity that it has. But I want to incorporate surveying and really talking to the community, as has been suggested by Miguel many times in the past. I will say that as thoughtful and strategic as the commission and the city council was with the dog park, we find ourselves in the same situation with the dog park as we did 4 years ago. And it would, even though it would be nice to have a resource center and new courts and restrooms and shade and everything else that they would need, it would really be a shame if 3 years from the time that that investment was made, it doesn't accommodate the velocity of it. And for a very small amount, in addition, 3 years prior, to grow it so it could be a sport we could grow into, and then ends up costing us 2 times or 3 times the amount. So I just want to make sure that we take the time to really look at option A, B, and C and make those recommendations. I think we could probably have those recommendations by September.
I would say, I come from the corporate world. I didn't grow up in the government world, and September seems like a lifetime
Forever.
away. So let me ask a question and ask how you all feel about this. We are dark, or we're planned to be dark in August, and I don't know that we. Yeah, as a commission. So let me ask you this: would the subcommittee consider making a recommendation to do the temporary conversion of the 2 courts that are today tennis courts to a temporary a temporary correction. It would have to be painted, so there's going to be some cost associated with it. But they would use the temporary nets so they could go back and forth. Would you consider a meeting at the Youth Center with the tennis and pickleball people from that community? Because we do have, and I know Travis will remind us that we do have a community, albeit small and not a professional community of tennis players who play at that park, and said they wouldn't be allowed on the courts at Ruth Hardy because they just weren't good enough and they didn't want to be, pushing good people off. So this would be an effort, because I know that the pickleball people would be very supportive of pulling off that court if somebody came along with rackets in hand and said, we're tennis players. But is that what I've said? Is that something?
That's what you said.
That's what we said,
You
yeah.
can read it again.
Well, yeah, except I thought you were talking about the free striping. The free striping, I do not believe.
I would like to pursue that.
Well, what I'm telling you, though, is the free striping is a single to single. It is not 4 courts on a tennis court. And that's not what you're asking for, right? You're asking for 4 courts on a tennis court.
Yes.
So it's not free. It's going to, what they were saying is to be able to use both is a 1-for-1. And that wouldn't, I don't think,
they'd pay for 2, so that would pay for 2, and then we'd pay for 2.
no, I think what they said is, we will come in
Okay.
and stripe 1
Okay,
court.
we'll relook at that.
I don't find that in there. I'm just trying to figure.
Okay.
Because it might be past the deadline too.
What is-
I'm gonna call them and see if they'll open that deadline for us.
So based on that, is the subcommittee willing to make a recommendation today rather than waiting till September? And what would that motion be?
Can I just say one more thing? My suggestion of September was for a long-term solution and not a temporary solution. And that is just because cities are dark in August.
Yeah.
And so, I think in the next few weeks, we could have many meetings with the pickleball community and I think we'll need a little bit of time for a more permanent solution. So that's where September was.
Right, so my solution is a interim solution. Is that something that everybody would entertain?
I would.
But it kind of depends on the answers that we might get when she calls for the deadline, right? I mean,
Well, my thought is if they could pay for 2, that'd be great, but if
It
not,
shouldn't inhibit our.
yeah, we could go
Yes.
forward.
I'd like to make
I was just gonna do it, go ahead.
to move forward with.
You're off on your mic.
So I'd like to make a motion that we move forward with the blending and the striping of the 2 courts at Demuth.
Property for 3262 North Micah Drive in Palm Springs was found on Airbnb.com under the title of Palm Springs Bungalow with Pool and Spa under advertisement number 171-38268. The department's code officer inquired online as to a short-term availability of the property for the dates of September 20th through September 25th for a total of 5 nights. And the host advised that the property was available. Advertisement of the property and inquiry contained that the owner was identified themselves as Daisy. You can find it on page 28 of your packet. The ad does state entire house for rent. That's also on page 28 of your packet. Ad states before you stay, we send you the code for convenient access. That's on page 29 of your packet. Ad also states self-check-in with a keypad on page 28. We do have on the record personalized replies regarding binder with places to go and keyless entry of the property on page 22 and 23. And we do have a pre-approved booking on page 25. Based on the advertised information and inquiry into the property, and property being offered as a vacation rental, not a home share by the host. Administrative citation number AB 070 in the amount of $5,000 was issued to Daisy Torres, an individual on title, for operating a vacation rental without a vacation rental registration certificate. The administrative citation was mailed by Vacation Rental Compliance Department to the address on title, and a receipt was confirmed. I do have the code officer that did investigate and issue this administrative citation present. If the board does allow, I'll be more than happy to bring him up and ask him a couple of questions. Thank you.
Any objection to the officer testifying?
No.
Do you want to do that? You want to do it now?
We could do it now, or whatever the board would like to do.
Let's do it now.
Okay. Great. Officer Williams, thank you. Hi, could you please state your name and your position within the city for the record?
David Williams, Code Compliance Officer with the Vacation Rental Department.
Great. Officer Williams, were you the one who investigated the property located at 3262 North Micah Drive?
Yes, I was.
Great. Would you mind telling us a little bit about the inquiry and about the advertisement?
We received, I think it was 3 or 4 inquiries about properties on this street. So when we received that many, I tried to investigate every property on the street. And this one raised a red flag simply because the ad states that it's for an entire house. So when I see something like that, I say, okay, let me see the ID number and I'll check that with our records to make sure it's valid. Well, the ID number she had listed started with an 8. That means it's a home share, so she couldn't be renting the entire house. So that was another red flag. So I pulled up the ad and I read that it was for the entire house. So I did have, I did send a booking inquiry and had several emails with the property owner. If you'd like, I could read those.
Just tell us what pages those are on.
On your packet, they are,
If I may, it's page 22 through 24. Correction, 21 through 24.
That's the exchange you mentioned, Mr. Williams?
let me just double check. There is additional correspondence that went, or interaction that went back and forth that it doesn't look like it's in here.
Okay.
There's a supplement.
Yes, it is.
Thank you, Mr. Mejia.
Thank you.
So this is the July exchange you had with the property owner
Correct.
regarding renting it for the September period?
Correct.
Anything further, sir?
No, not at all.
All right, if you just keep your seat. Anything further, Mr. Stark?
No, thank you.
Any questions of the staff report at this point?
The only thing that comes to mind is the evidence that it's a home share versus a vacation rental. If there's evidence that it's a vacation rental, it will convert from the home share to vacation rental. Like, for example, if the person has like in this case, the vacation rental permit, if they're renting it out as the home share permit, and they're renting it out as a vacation rental, then the board or the city views it doesn't matter what the application is, it's the conduct that defines the violation.
Correct. It's actions and advertisements that have, in this particular case, have taken this home from being a home share into being a vacation rental. And the way we view a home share is when an individual lives at the property and resides on site during the term of the guest's stay. In this particular case, during the exchange between Code Officer Williams and the host, Ms. Torres, he does ask, will there be anybody else on site? And Ms. Torres does identify and says that there will be nobody else at the property except yourself or your party. And based on that, owner not being on site, it then does become a vacation rental. That is the major significance between the two.
Okay.
I just have one question, and I think you've answered it. When I read under the space on page 29, it says permit number 8309, this home is officially registered with the City of Palm Springs as a vacation rental. And you've already stated that any registration of the starts with 8 is in fact not a vacation rental, but a home share. Is that correct?
Correct. There are a series of numbers that we use for our staff to be able to identify a home share versus a vacation rental. And this was a perfect example of that system working, where a code officer saw a permit number, and based on what the ad stated and the number, it didn't match, which then further escalated into further inquiry of the property.
Thank you.
Okay.
Does the ordinance have a provision for disposition of the home share certificate in the event this appeal is upheld?
I do not believe it does. I would, no, it does not. According to Assistant City Attorney, it does not.
So the position would be that the home share status would continue to prevail, notwithstanding this violation being upheld.
Go ahead.
Assistant City Attorney Peter King, that's correct.
Okay. Any other questions of the staffer?
Not at this time.
Okay. And is the appellant present? Daisy Torres?
I'll just note that we have written, under the penalty of perjury, documents from George Torres and Daisy Torres. No, they get 10 minutes as the appellants.
Okay, thank you.
All right, Ms. Torres and Mr. Torres, for your appellate presentation, you have a total of 10 minutes that you can use between the two of you. So you can proceed now however you'd like.
Okay. What I wanted to say is that, yes, we did get a permit for home sharing. And yes, we have rented the home in the home share where we've had guests stay with us. And in the explanation that we put was, it said something like we were toying with the idea of switching over to vacation rental, which in fact, it wasn't that we were thinking of it. It was more like I was thinking of doing that and trying to convince my wife, but she didn't really want to do that because we don't obviously have somewhere else to live as of now. And I went in her account because the Airbnb account is in her name only.
Every what?
The Airbnb account is in her name only. And without her knowing, I went in there and adjusted, switching it over to entire home versus home share. And, but I only did it thinking I was only gonna, I was just kind of playing with it. Not thinking that I was gonna get a request or a inquiry. And when I did get the inquiry, I still kind of like went along with it, but kept it a secret from her. And she didn't find out until, you know, we got legal documents, and then I changed it back. So no one has stayed there using the entire home. And I'd like to add that I'd like to apologize to you guys for doing that, not being honest, and also apologize to my wife because I obviously, because of that, the consequences that she is now here in front of you because of my actions, not because of her actions. So I'm sorry.
Is there anything else either of you would like to present? And is there any other testimony on this appeal?
I have no other request to speak.
All right. Board members have any questions of the appellants? Yes.
More is, I guess, a matter of just of curiosity rather than law. How long did you have your home on the Airbnb site listed as a vacation rental? If you have any idea.
Yeah, I do have an idea. It was maybe a few days because I, after I got that inquiry and it didn't go through, I tried to switch it back, or at least I thought I switched it back. But then when we got the documents, then I realized that it was probably still on there as an entire home. So I want to say maybe like a week or two, because we got legal documents from you guys almost immediately.
When you say it didn't go through,
in other words, when the code officer did the request, right? That's called like a pre-approval inquiry, and it only lasts about 24 hours, and then it expires on its own, because he obviously was not gonna book, because he's not gonna stay there, because he's, just inquiring. So then when that expired, 24 hours later, I switched it back, or at least I thought I did, because I believe that the Airbnb site's a little bit confusing or hard to, work with. So I switched one back, because they're like a series of buttons, and I switched one button back thinking that was gonna fix it. But then when I got the legal documents, I went in there to verify, and there was still one more button to press, and then I switched it back.
and in your Airbnb documents, you stated that the permit 8309, which we now determine is a home sharing permit, it says that this home is officially registered in the city of Palm Springs as a vacation rental. Can you explain why you said that, knowing that 8309 was not a vacation rental? Or you were advertising as a vacation rental, but the 8309 was for a home share?
Yes. In that statement, I must have put vacation rental by accident, not knowing the correct terminology as far as saying, home share. But yeah, we've always been registered as a home share, and the people that have stayed there have shared the home with us.
Any other questions of the appellants?
So your petition and the consideration you want the board to make is that it was kind of an inadvertent, it's mistake.
Yes, exactly.
And that it was almost an error or technical malfunction.
Yes, correct.
And that you previously had been operating as a home share, and after this citation, are you, I assume you're continuing to operate as a home share?
Correct, that is correct.
And that, so it was just during this brief window of time when you had played with the idea of maybe converting it to
A vacation rental.
a vacation rental?
Yeah,
And the permit, did both you and your wife apply for, is it the permit, the home share permit issued in both your names?
no, it's only issued in her name, and the house is only in her name, and the Airbnb account is only in her name.
You might have to change your password to your.
Yeah, I no longer have, after all this, yeah, she changed her password. I no longer have access to her Airbnb account. That's,
You hijacked it.
yeah. It's very embarrassing to say, but yes, that's what I did, basically.
Okay.
I have one for, all of these reviews, the 108 reviews, it's unclear, at least from the ones that I read, whether they are vacation rentals or whether you maintained your residence in the house. Are you telling us that all those 108 reviews were for home sharing?
Correct, that is correct. Yes.
Anything else?
Okay, thank you.
Thank you.
All right. Anything further from the staff?
Yes, Vice Chair, if may we add a couple of comments? Thank you. Home share was designed and passed by the subcommittee and the city council as a way for individuals to make extra income, especially in the city of Palm Springs, because we have so many individuals retiring, and it was meant to allow members to rent out, homeowners to rent out parts of their home to offset some of the expenses that they have, and they were supposed to be on site during the entire guest stay. The ad itself does raise several red flags. One on the first page that was not noted in the staff report is the bed, how many occupants you can have and how many bedrooms the property has, which it says it has 6 guests, but it's a 2-bedroom, which could only have 4 guests. The other concern that the city had when we reviewed the site was that included a keyless entry and a statement, before you stay, we send you the code for convenient access of the property. And in addition, during the investigation, you will notice on page 31, there is a review by an individual, Claudia, that says Daisy was very responsive. We had a few questions and she replied immediately. And in a way, we would have a concern with that reply of the guest when somebody is responding very quickly, they may not be at the property during the term of the guest. I think that what is really important to understand is that an individual may not shift between a home share and a vacation rental. It requires different type of a permit, and those permits have different requirements within our ordinance. And I think that's what's important to recognize, and because it does have different requirements, there is a different fee, and there's a different level of enforcement that this department has to do. Thank you. That completes the city's comments.
I do have one more question. One more question for you folks. What would you have done had this been a quote-unquote real inquiry, not from the city? You say you don't have any place else to live.
Yeah, that's correct.
What would you have done if you had rented it?
To tell you the truth, I don't know what I would have done. I don't know where I would have gone. I mean, I don't have a plan B. It's just, like I said, I was just kind of playing with the notion, and then I started getting that inquiry, and then I switched it back because of that, because I don't want to, I don't know where I would go. Yeah.
Okay, thank you.
All right, so having heard from both sides on the appeal, do we have any comments from the board members?
with
Or-
respect to our discussion?
Yes. Yes? Sure. I'll start if you'd like. Go right ahead. Well, it appears that the city's position is that the investigation that was conducted where they sent inquiry that the response that the entire house is available for rental constitutes a violation because the entire house, by definition, means that there's no one else sharing the house. I seem to recall reading some reviews, maybe it was in this case, maybe it was in some others, where there was home sharing and there was some clarification about one of the guests wanting to home share, that they showed up and there was other couples in the house. And they thought when they had booked that they would get the entire house themselves. And when they showed up, you know, one bedroom was one couple and then they rented another bedroom. And, you know, there was this kind of misinformation, you know, like in this world of texting where people, you know, not the full idea is conveyed when people are using these interaction type devices. But what I didn't hear from the city was evidence actually that you guys were not present at the residence, you know, other than the reference that in the response that you were responsive and that you had, with a few questions you had replied immediately, which I think the city's position is that that was some type of text reply, that you weren't present or something like that, I think is my understanding of that. At the same time, that's not clear to me that you weren't present. You could have been very responsive by coming out of your room and been responsive to the homeowner or the renter, or you could have replied immediately to a question. So, I mean, that's not super duper clear to me that you were not present at the home. So I'm wondering, do I need to see, you know, is there need to be evidence before the board that that you in fact engaged in vacation renting, other than, you know, by your inadvertent technical mistake? I don't know. That's my question I have for my other board members.
My thought on that, first of all, I understand your position in terms of tinkering with it and not pressing the right buttons. But the law, and correct me if I'm wrong, states that if you hold it out as a vacation rental, whether or not anybody actually rents it, is still a violation. This does present a little bit different case than some of the others that we've seen where someone has a history of has a history of putting the house out as a vacation rental and has a history of actually renting that house over a period of time and now has gotten caught. Those cases are pretty clear cut in terms of the violation, whether or not there was an intent. So this is a little bit different a case. I'm sympathetic to the situation between the two of you. It's unfortunate, but it's a little more difficult for me in as much as up until this date, if we take the appellants at their word, it had been a home share. It had been only offered due to this, your words, tinkering for a very short period of time. You have no place else to live were this to actually go through. So it sounds like it wasn't a particularly well thought out financial plan on your part, as has been the case in a number of the appeals. So this is a more difficult case for me as to how we resolve it. My assumption, and correct me if I'm wrong, is that when you walk out of here, regardless of how we find your appeal and the amount, that you're going to be doing home sharing in any event. Is that correct?
So repeat that. I didn't really understand that.
The last part, yeah. I didn't understand the last part.
Okay. So, what are your thoughts?
Well, I share the understanding and sympathy of my fellow board members toward the situation, but I don't find there to be any facts in dispute here. It's pretty much established what happened. This was a registered home share. It will continue to be a registered home share. But with whatever intentions, this misadventure into the vacation rental market occurred deliberately. And as we all know, that constitutes a violation of the ordinance, and it was discovered by the city staff in response to information from the community, and the circumstances were confirmed. And so I don't see in the facts or in the law as we know it any basis for overturning the violation. Anything further from either of you? Is there a motion?
Prefaced by some sympathy for the appellants here and some economic hardship in having to pay a $5,000 fine based on your tinkering with your Airbnb account. I would move that the resolution of the city making this property, the Daisy Torres property at 3262 Micah, permanently ineligible to operate a vacation rentals should be adopted. And likewise, I would move that we adopt the resolution of the Palm Springs Board upholding the administrative fine of $5,000.
Is there a second? Understanding the motion to be to adopt resolution 2A and 3A, I'll second the motion. Roll call.
Board Member Cronander?
Aye.
Board Member Cleary?
Nay.
Vice Chair Howard?
Aye.
Motion passes 2-1.
Thank you.
Thank you.
One question, had you explained to the appellant that you are subject, or that they can come up with a payment plan? Okay. Out of economic hardship? They're just standing right there.
All right, we'll move to item 2 on the agenda. This is an appeal of the administrative decision that Janie Hooker is permanently ineligible to operate a vacation rental in the city of Palm Springs, and the administrative fine for operating an unregistered vacation rental property located at 282.
Oh, sorry. Shoot. I'll turn this off. My apologies.
2821 North Los Felices Circle West, Unit K213, Palm Springs, California. Staff report.
Thank you, Vice Chair. The property located at 2821 North Los Felices Circle, Unit K213, did not hold a valid vacation rental registration certificate from our office as of the date of the administrative citation, which was July 2nd, 2018. Staff has determined that the current owner has, without a registration certificate, advertised and operated the property as a vacation rental. We are noting that short-term renting is not permitted in this particular community, and our office has been noticed as such. We've included a copy of that letter from the HOA president at page 23. We've included the Palm Springs municipal codes and regulations that apply to this case. Specifically, on June 28th, 2018, the violation occurred. Our office did find an advertisement for this property on Airbnb. The website stated cozy, cute, and convenient under the advertisement number that we've included in the staff report. Our department's code officer inquired online to see of short-term availability of the property from August 23rd to the 27th, which is 4 nights, of course, would be accepted, and the host responded affirmatively to that inquiry. The ad of the property in the inquiry included significant information, including the owner is identified by name as Janae. That's page 30. The ad says, "My place is close to restaurants and dining. My place is good for couples," etc. The entire condominium is available for rent, as you can see on page 30. Check-in time is flexible. That's on page 31. The host/owner also provided personalized replies to our officer during the communication regarding the inquiry, and that can be found on page 26. Based on the advertisement information and the inquiry to the property being offered as a vacation rental by the host, our office did issue administrative citation AB 0163 to the owner on title. The citation was mailed to the address on title. Our department confirmed receipt. One thing that we are noting is that our department has worked with Airbnb to include a responsible hosting page. And our purpose in doing that was to make sure that as individuals signed up to be hosts on Airbnb, that they could clearly see that Palm Springs has rules around this and that they do need to be registered. And we've included a copy of that on page 37 of your package. Officer Gomez is here today. He's the officer from our department that conducted the investigation and issued the citation, and he and I are both available for questions. Thank you.
Any questions of the staff report?
Hi.
Hi.
I noticed on the paperwork, there was an indication on page 32 that the host canceled the reservations 29 days before arrival. This is an automated posting. What does that mean?
That would indicate that the inquiry did not go through, that the host did not accept the reservation after all. So a host can set up a time limit in terms of responding and also in terms of following through on the reservation.
Okay, so a party wishing to reserve or book a place, the host can cancel that, even if the party says, "Yeah, I want to rent that place."
The host can do that, yes.
So that can be done anytime up until the money is exchanged or the deposit is made, or how does that work?
Yes.
And so, when is the actual guarantee or that is your rental done? Does it require payment for that to be secured?
Yes, you'd get payment and you'd get a confirmation of payment.
So up until the confirmation of payment, it can be without, any reason, for any reason, can be canceled.
I believe so, and Mr. Stark has information to illustrate that it can actually be done in certain cases afterwards.
When you see, what you're referring to in your packet, that review that the host has canceled, there is a cancellation policy that every host can set up within what they prefer. Some hosts set up that you cannot cancel 30 days before your arrival date, or your money doesn't, or you don't get your full refund, or 50%. So there is a cancellation policy that host can set up per, how they wish to set it up. In that particular case, from what I'm seeing in the packet, is that the host did, and the host agreed with the guest to host them at their home, and for whatever reason, the host canceled that booking. And the reason that it goes on the review page is for any future bookings, people that may inquire, Airbnb wants guests to be aware that the host has canceled previously set booking in a transaction that was supposed to take place. Does that,
Which would be important.
does that help answer the question?
Yeah.
I apologize if I made it more confusing.
No, and that helps, because I see that listed there, and I'm wondering, when is the reservation made, when is it, done?
So just to clarify, since, in terms of our protocol, since advertising is operating, we find the ad, we reach out, we don't actually go through with the booking, we don't give the host a credit card. We inquire as part of the investigation, and if they accept the short-term booking, and it's clear to us that there's some personalized response and not an automated response that also the host can set up, then we believe that that's sufficient evidence that there was an intention to rent short-term.
Okay. So this is the one that also got the homeowners association, received notice from the homeowners association that there was no short-term rentals allowed at the association. Is this the same case?
There are two cases today where the same HOA is involved.
Oh, okay.
In this particular case, our office has been notified specifically regarding the HOA's CCNRs in this regard. Our policy is, and the ordinance requires, the new ordinance requires that we obtain a letter from the HOA when someone applies or when someone who had a certificate renews. And because we couldn't necessarily rely on self-certifying at the application time. Some owners didn't know, sometimes it was unclear. So our new ordinance that became into effect last April 2017 requires that we actually get a letter from the HOA or the management company that states if the city issues a permit that the owner will not be in violation of the CCNRs for that HOA community. And that's the practice that we follow. We included the package here just as a note that, and let me just back up. So in this particular HOA, like many HOAs, have made it clear to the city that they do not allow vacation rentals, and we honor that. And that's why I included this. And this particular HOA has provided us a copy of the CCNRs. They've provided us, they updated their rules and regs this year, and they provided the city with a copy of those. They're not required to, but they're very proactive because their community members have voted against vacation rentals, at least until this point. So, and they have also indicated to us that the management company has sent out newsletters reminding owners that they need to pay attention to the requirement.
And if I may, Peter King, I asked to actually get a copy of the CCNRs and get a copy of rules and regulations, and it, having done legal work for HOAs in the past. And what I found is it was very clear in their original documents that they did not want hotel-type stays. And as late as 2018, they revised their rules and regulations to specifically say that you cannot do vacation rentals. And Ms. Severin provided me with the documents, and I reviewed those just to satisfy my curiosity that they would be fully informed that that was not allowed.
All right, any other questions of the staff?
Would you like Mr. Gomez to come up, the code officer?
Whatever you're,
Okay,
there,
thank you.
there are no questions of him. If you'd like to have
Oh.
him present his testimony,
Okay.
then we can do that.
If it's not necessary, that's fine,
All
thank
right.
you.
Okay. Janae Hooker?
And I'll note that we do have the signed documents stating that her testimony is under penalty of perjury.
Hello.
Good afternoon.
You have 10 minutes. You start when you're ready.
Okay. So I first off want to start off by saying that I know that ignorance of the law is never a defense. However, when listing my property on Airbnb, it was pretty much just to gauge interest in the property because I was in the process of deciding what I want to do with the property. And so I do have evidence here of how I listed it. I did get an inquiry, which was a month before the person was supposed to stay there. And so the property, first of all, is empty. It's not even operational. I cannot rent that legally, and I have pictures to show that. So the person did inquire, and it was almost a month in advance. So I kind of played with the idea of doing what was necessary to get it set up. Then I realized I'm not going to be able to do that, and so I did cancel the inquiry or whatever the person did. So that's one thing I wanted to say. In my letter to you, I said that the property, I would provide pictures that it's empty. I have bank statements that show that there was never any money earned on this property. I have an agreement that shows I'm now selling the property because that's what I just wanted to know, like, what can I do with this property? I had it, I bought it as a vacation home. I never go to vacation there. And then also someone said just now something, about the HOAs and all of that. It was not clear about the laws because I specifically called my HOA and I left messages, at least 2, asking them, because I remember I live in Carson, California, first of all, so I remember getting numerous packets of letters from them, and it said stuff like, we're voting to see if we're gonna be a rental property and things like that. So I did call twice. Again, that's just me trying to find out what, if I do decide to go with the short-term rental, what do I need to do in order to do it? I deactivated the Airbnb as soon as I received your citation letter or whatever it's called. So I have evidence of that as well. That's all I want to say. Do you need to see this? Because it said, like, make 15 copies.
Sure. Mr. Mejia, maybe you could show them to the city if they haven't seen them.
Yeah, well, they need to be available to the public as well, and I don't know that that can be accommodated.
Well, I have enough copies.
Do board members want to see those?
Yeah. Thanks.
I have a property in the same community, and I think that there's something really important.
All right, sir, well, we'll have public comments. You need to fill out a request with the
Asking permission. That's
city
all.
clerk. Okay. All right, any board member questions of the appellant?
Just to clarify, you only deactivated the account after you were notified that you were in violation.
Yes. Not because, like I said, I was deciding, and if I don't necessarily believe that I'm committing a crime, I didn't think to deactivate it, but I've never rented it. So if I didn't know that advertising on Airbnb is a crime until you notify me, I wouldn't have any other reason to deactivate. And as I said, I was using a period of time to decide what I wanted to do with the property. If I want to do a longer term rental, which is legal in our community, or if I wanted to sell it or try to go this route. Not knowing whether the HOA, because like I said, it was always a vote, and I called twice and left 2 messages. So yes, that's true. I did deactivate it once I received it.
Let's understand that we don't do crimes here. This is not a criminal action. You've not been charged with a crime. This is an administrative hearing for a violation of the municipal code. Any other questions of the appellant?
Just one more. And how long did you have this property registered with Airbnb?
I honestly don't remember, but I believe for purposes, I printed bank statements from May, because I think maybe it was on there on May. But like the gentleman before, the website, once you get on, it is a little hard to navigate. It took me a few days to actually figure out how to deactivate it. So honestly, I can't tell you when I had it listed. I want to say maybe late May.
What happened at the beginning when this board initially started to wrestle with these issues as to whether there's an operation of a vacation rental or not, one of the questions that came before the board was this exact same situation that you're in, that someone who's maybe doing a test rental, trying to see what the market is there any value to renting their place out? Can they buy a second home and rent it and make a go of it? And the ordinance was prohibiting rentals. Did advertising or doing a test market, and we wrestled back and forth, and then the city in its infinite wisdom decided to define for us what operation meant. And their definition included that a property means that any web-based advertising hosting platform, print media, bulletin, signage, radio, or television, or any other medium for the purposes of promoting interest in, testing the market for, or soliciting the occupancy of a property for a period of 28 consecutive days or less. So the city had effectively defined for us that they wanted us to understand as a board determining whether violations have occurred, that someone who does what I just read is considered to be operating a vacation rental. I looked at your photographs. It's clear that you couldn't operate a vacation rental if you wanted to. There's no furniture. But you don't have to either. So the city wants to include in the people that are prohibited are people like you who are merely testing.
I do realize that once I received the citation in the mail that advertisement, acts in this city says that advertisement is a violation. So I do realize that, and I'm hoping that the evidence shows that I didn't benefit in any way and make any money that the city should have made, or my actions didn't prevent the city from making money or losing money. And I'm very apologetic for advertising illegally in this city, which considers it as operation.
Anything else?
I'm sure I'll think of it when I get home.
All right.
Oh, and then whenever, as your bylaw said, whenever the public speaker.
Okay, I want to make sure you're finished, and then we'll move on.
I also have evidence like there's no spikes in electricity and things like that because it was never used.
Anything else?
No. So, no, I don't have anything else.
All right, thank you very much. And do we have a public comment request?
I don't have a public comment request, and the gentleman just left the room.
All right. Any rebuttal by the staff? Further information?
No, thank you.
All right, comments, deliberation by the board members?
I'll begin. This is one of those cases that, is kind of like one of those gotcha cases where, technically you're in violation of a very technical aspect of what is defined as the operation of a vacation rental. But I think the intent of the ordinance was to prohibit actual renting of the vacation rentals. That's the real intent of the ordinance is to prohibit people from turning their condos into hotels. And it seems to me that for someone like you who may have mistakenly done a test market, you qualify for a violation under what the city defines as operation. But I don't think that really you're the heart and soul of what the city is trying to prohibit or punish. You've indicated you've never rented the place out, you never got any income for it, there's no evidence that anybody stayed there. The pictures show that it's empty. And with your HOA, and I mean, now that you're selling the place, you won't have to grapple with what to do as far as long-term or short-term rentals. But it seems to me that maybe it's a technical violation, but I don't think it's a real violation. And the idea of prohibiting you from vacation rentaling for life, and when your intent is, and you've shown us that you're listing the place for sale, and that is on August 15th, recently, that you've entered into an agreement to list the vacation rent, the home that was alleged the subject of the vacation rental for sale. So maybe you can be snared into the net, but I don't think that's the intent of the statute, and I don't think you should be.
Yes, sir.
Not surprisingly, I guess I would disagree. We don't know what the heart and the soul of the city was in drafting this particular provision. And we cannot rely on that heart and soul or real intent in making our decision today. And in fact, although I'm sympathetic to the appellant's case, this is not a technical violation. It is a real violation of a real ordinance. And there was care taken in drafting this portion of the ordinance to include advertising of any sort, and it goes on to describe all the methods of advertising. And it is a separate violation to advertise, not simply to rent the property, pay a TOT, and make a profit for it. So I would disagree that you're not being caught up in a web. You are being caught in a violation of the statute as written. That's all.
Thank you. Any other comments? Is there a motion for disposition?
I would move. I would make a motion that we accept the resolution, accept a resolution upholding the administrative decision that Janie Hooker is permanently ineligible to operate a vacation rental at 2821 North Los Feliz Circle, Unit K213. That is 2A and also 3A. That we uphold the administrative fine of $5,000 to Janie Hooker for operating the unregistered vacation rental property at 2821 North Feliz Circle, Unit K213.
Thank you. Is there a second? I'll second the motion. Roll call?
Board Member Cronander?
Aye.
Vice Chair Howard?
Aye.
Board Member Cleary?
Nay.
Motion passes 2-1.
Is
Thank
there any reprieve, like can I get a lawyer?
We cannot give you legal advice.
Okay, but
so-
I do want to know if there is any reprieve for this.
All right. Thank you very much. Okay. Agenda item 3 is an appeal of the administrative decision that Adam Bray Ali and Tracy Cambron are permanently ineligible to operate a vacation rental in the city of Palm Springs, and the administrative fine for operating an unregistered vacation rental property located at 2821 North Los Felices Circle West, Unit K208, Palm Springs, California. We have the staff report.
Thank you, Vice Chair. The property located at 2821 North Las Felices Circle West, Unit K208, did not hold a valid vacation rental registration certificate from our department as of the date of the administrative citation, which was July 3rd, 2018. Staff has determined that the current owners have, without a certificate, advertised and operated the property as a vacation rental. We would like to note that the owners previously did hold a valid registration certificate for this property. It was issued on April 14th, 2016, with our new vacation rental ordinance that was effective April 16th, 2017. New and renewal applicants must provide a letter from their HOA board or their management company that short-term renting is allowed. The Vacation Rental Department issued administrative procedure covering this requirement on March 1st, 2018. That's included in your packet at page 27. By way of history, the owners did send a renewal check to our department in March 2018, but they sent no renewal application with it and no required HOA letter with that application. Staff reached out to the owners by email to request the required documents. That was on page 20. On May 10th, our office advised the owners via email and letter that the HOA associated with this property had provided notification to our department specifically that short-term renting is not allowed, and therefore the owner's application and renewal fee check was being returned. Our email to the owners clearly states that they may not advertise and operate as a result of this. I will note that the owners did send us pieces of an application. We never did get a letter from the HOA because they don't issue them for short-term rentals. I've included on page 28 the HOA board president's email to our department that short-term renting is not allowed in this particular condo complex. In your staff report, we've included the Palm Springs Municipal Code sections and the regulations that apply to this case. Specifically, the first one down is that new ordinance requirement that we do require the HOA letter with an application. Our office determined that a violation occurred on June 25th, 2018. Our officers found an advertisement on VRBO. The property was advertised as Happy House Palm Springs under the advertisement listed in the staff report. Our department's code officer inquired online to see if the owners would accept a short-term inquiry, specifically from August 3rd to the 10th, which of course is 7 nights, and the host did respond affirmatively. The advertisement of the property and the inquiry that we sent are included in your package. I'll note specifically that the owner is identified on the ad as Tracy Cambron. Also, the advertisement specifically says a minimum stay of 2 nights. There was a personalized reply from the owner to the inquiry that our officer made, and there's other information included in your staff report to represent that advertising did occur. So based on this advertisement and the inquiry into the property, our office determined that a violation occurred. We issued citation AB 0166 to the owners on title, and we confirmed that citation was received. Officer Rasmussen, who did the investigation and issued the citation, is here, and if you have questions for he or I, we're happy to answer those. Thank you.
Questions of the staff report?
Just a point of clarification, as this hasn't really come up, at least during my tenure here, would you review once again for me how, in a case of renewal such as this one, I think what you're stating is there are a number of checkoffs that you need in order to renew the permit, and that one of those is a letter from the HOA. And in this case, you did not receive that letter because they prohibit this kind of short-term rental. And without putting words, I guess I am putting words in your mouth. And because that letter was not received, the permit, or the renewal of the permit was not allowed. Is that correct? I see you're shaking your head no, but, and you obviously have a chance to talk. But am I correctly stating your position? Or is there a nuance there that I'm missing?
No, what you're stating is correct. We do have an application and renewal process, and there are a number of pieces to the application. The requirements need to be met. We do have a checklist, and we make sure that we have that information that's required by the ordinance before we issue a renewal permit. I will say that with respect to HOA letters, I mentioned earlier today that our office issued an administrative regulation that you have in your package specific to this requirement. And we did some outreach to owners that had certificates, but we did not have a letter for those. So during the March, April, May timeframe, in addition to the information that I've stated today in terms of the administrative regulation that we issued, we did send letters to owners and ask them to provide the HOA letter. So in addition to renewal applicants, we sent them to all owners and tried to handle this all at once, as opposed to waiting until the renewal occurred. So we had a very focused effort around HOA renewals that coincided with this particular renewal.
And in this case, when you didn't get the letter from the HOA, you send out an email to these specific owners saying, we need this letter or your renewal isn't going to be valid?
We, in this case, we had several HOAs that were very proactive during the March, April, May timeframe with our office. They wanted to make it very clear that they did or did not allow vacation rentals. Palm Springs Villas 2 made it very clear to us by way of letter that's included in the package from the HOA president that they do not allow short-term vacation rentals. And it was at this same time that we received a renewal check from the owners of this property to renew their certificate. The check is not enough. We reached out to them and said, we also need these other things in order to renew. And probably a month and a half later, we got very specific guidance from this HOA that said, do not renew the following properties. They have certificates. We don't allow it. And please don't renew these properties. It's in violation of our CC&Rs. So we had very clear direction from a number of HOAs, one way or another.
Okay, thank you.
You're welcome.
Any other questions of the staff report?
Just one, Ms. Severin, you indicated that there was the CC&R letter that came from the city kind of indicating the requirement that there be verification, that there are no rules, regulations, covenants, and restrictions prohibiting vacation rental. That's in your packet on 27 and 28. Is that the same document we're talking about?
Can you pull up those letters that we sent? This is the administrative reg that our office issued, signed by the city manager and the city attorney. There were two separate letters that I did not include in this package that were letters that went to all owners and all agents that manage these properties. We issued that letter on March 12th, and it basically said that this letter is an important reminder that the ordinance requires a letter from your HOA or governing management company. And we asked them to send us the letter by April 13th, 2018. And we went on to say that it's a violation to operate without this letter. And we attached this particular admin reg. We did not get a letter from some owners, so we sent a final notice out in April. Okay. Okay, we sent a final notice out in April. I don't have that letter handy, but it basically said that if you can't get the letter, the HOA letter, and you're currently registered, you either need to close your account because we can't continue to allow you to operate. We can't rely on anything except a letter from your HOA, or you would be cited for continuing to operate. And I'm sorry I don't have the date, but that was in April, and I believe we gave everybody until May 12th to send that to us. That was in addition to this specific situation that was going on.
With individual correspondence regarding that?
That's correct.
Is there anything to the discrepancy regarding the fee schedule that's set by the ordinance signed by Dr. Reedy and Mr. Kotkin, where they indicate that the first violation is $500 and it escalates from there, versus the citation that was issued in this case, which is the first violation for a $5,000 penalty? Is there a reason there's a discrepancy there?
In this case, the owners specifically were told that we would not be able to issue a renewal certificate to them, and that we had specific instructions from the HOA, and that the city honors those, the CC&Rs, because it's the community speaking. So they take precedence over our ordinance in this case. There's an email in this package where I specifically let the owners know that we had received correspondence. It's on page 22. I had specifically, at this point, we received the letter from the HOA. So I let the owners know that we would be sending back their check and the pieces of their application that they did submit, because our office was not in a position to give them a renewal certificate. So that was that, and then our officers, actually found them advertising. So in this case, it was clear that the owners got the email. It was clear that the owners they got the email. They said that they were further discussing this, but the email did state that advertising and operating is a violation.
So I guess my question is the fee schedule indicated in the CC&R requirement a fee schedule that goes to failure to provide the letter from the HOA, subjects the permit holder to a $500 for the first offense, $1,000 for the second offense, and not to exceed $5,000? Is that what that is a fee schedule to the permit holder for failure to provide a notice from the HOA that the vacation rental doesn't violate the CC&R's? Because it's a different fee schedule. I think maybe I'm saying it wrong. Fine schedule, payment of.
Yeah, I understand. So there were owners who were attempting to get those letters, albeit slowly. But we knew that they would be able to get those letters. We had information and we communicated with owners. We at a certain point, we reached out to HOAs and said, "Are you going to give us the letter, or aren't you?"
You knew who was going to be permitted and who was not.
Right. And if someone was having a hard time getting that letter and not putting a lot of effort into that, our office expended a lot of resources over those 3 months trying to get all of this squared away. Like I said earlier, previous to the ordinance, we didn't ask for a letter. We relied on the owners and the statements they made in the application. So the reason why in this particular case the owners got a $5,000 citation is because the owners were told their HOA wasn't going to give us the letter, that they could not renew and they could not operate. And they continued to operate.
Okay, so in this particular case,
yes, this
homeowner is being cited for failure to provide the letter from the CC&Rs, and your history is that that CC&R is not going to permit it. It's prohibited by
correct.
The CC&Rs.
Correct.
But this homeowner is being cited for failure to provide the letter.
This homeowner's cited for operating a vacation rental without a certificate. And it seems to
correct.
me the whole issue with the HOA and you can or you can't, this violation occurred regardless of that issue. There was a failure of the renewal here for whatever reason as of May, and the violation was recognized and cited in more than a month later. Isn't it just that simple?
That's correct.
But I thought he had a permit.
He
didn't renew it.
Because he
the evidence so
didn't
far.
Provide the letter.
Whatever. There's a whole checklist.
But there's a regulation signed by Mr. Reedy and Mr. Kotkin indicating what the procedure is and the fine schedule is for failure to provide a letter. And it's the law and regulation. I'd like the city's opinion as to that. I mean, isn't this the law?
If I may, Peter King, if you look at the 5.25.090, the ratcheted up first violation, second violation is related to somebody that I believe is related to somebody that has registered, but they've had other violations failing to post on the property. The $5,000 fine comes in section D, or excuse me, C of 5.25.090, and that's somebody that just hasn't registered at all, never, has not received a certificate as they should receive a certificate. And this is being treated as if somebody has not received a certificate because he didn't have a certificate. He may have had one once before, but he didn't have one now, and that's why they're applying the $5,000 fine, because it was clear, and I might argue it should have been clear to him through his HOA and through the letters that he got that he couldn't register, and he was going ahead to do it anyway. So that's the distinction that I see in reading this.
Okay, so he's being cited under one section, which is you don't have a permit section, D.
You don't have a permit at all, that's right.
But the correspondence with the city was about the other section, which was the one that has the separate fine schedule, and it's about whether or not I mean, the correspondence between the city and the homeowner are all about the CC&R and the regulations.
From the city's point of view, as I understand it, the correspondence does include the fact that his HOA does not permit it, and they never received verification from the HOA that he could receive a certificate. But what they're really citing him for is failing to register, period. Not having as if it was the first time he was ever trying to get a registration certificate. And they were going back and forth saying, if you want to register, we need a letter from your HOA saying that it's okay with your HOA. Now, contrast that with somebody that has registered, but they haven't followed the other rules that go along with being a registered vacation rental and getting dinged for the trash or for the first time.
That's a $500 fine.
Right, the type of thing that you've seen before. And so that's the distinction here. And I think it's a little bit of I wouldn't get caught up in the fact that what they were asking for was whether the HOA allowed it or not as a violation of something where he was already registered. He just couldn't register.
Right. So, but what I'm seeing is an individual who had a vacation rental certificate. The HOA passed a law saying, I'm just assuming here, somehow their rules and regulations became known that it was prohibited, and that terminated his certificate for vacation rental. It wasn't because he violated the law or he was doing it for less than, you're nodding no too, but that's not what factually happened here, that the certificate was not renewed because the CC&R said no. That's not why he was.
If I may interject, though, the CC&R was one of, or the letter from the CC&R was one of many items on the checklist. We wouldn't be having this conversation if one of the other items wasn't received. For instance, a notification, I don't have it in front of me, of proper insurance. The CC&R letter was just one of many requirements that he had to comply with to re-register his vacation rental. So I don't think we should be getting hung up on which of those items on the checklist he could not or would not provide. He did not complete the checklist. We wouldn't be having this conversation if it was about the insurance provision, which he also had to comply with. So I think we're muddying the waters by zeroing in on what his condominium, bylaws stated or didn't state. He did not provide one of the items that is required on the checklist.
Right.
So I think it's pretty straightforward. I think we just get muddled up when we start talking about the CC&Rs and so on.
Well, and the rules and regulations discuss a different fine schedule for people who do not provide the letter from the CC&R. There's a different schedule and a different administrative regulation that pertains to this failure.
He's not charged with that violation.
They're just picking and choosing the violation that they're going to issue?
you know,
Yeah.
what can be done about that?
Well, we can find that that's not the correct code section to cite the person on.
If I may, if you look at the actual citation on 16, he's being cited for operating a vacation rental without a vacation rental registration certificate. And the violation is 5.25.090C. Just, it's really that simple.
The evidence so far presented, we've yet to hear from the appellant. But to my ear, the evidence so far presented does establish the violation that's cited. So we've heard half the case.
All right, let's hear the other half, perhaps.
All right. We have Mr. Cambron?
That's the empty seat.
Oh, okay.
You did really well the first time, so I'm looking forward to
Mr.
it.
Bray Ali.
You got it.
That's you.
Perfect.
All right, sir.
Thank you.
You'll have 10 minutes. Please proceed.
Thank you for pronouncing my name right. I know it's not an easy one. And thank you for your time today. Appreciate you and what's going on here. I'm incredibly amazed by the nuances and the rules and the additional pieces that are here. I'm here not to try to argue or fight the system, but rather to add a little bit of history to the case and request a reduced fine and potentially a non-ban of me personally. That's why I'm here today. So as you heard, we have a condominium that's in this neighborhood called Palm Springs Villas 2. Purchased it with my good friend Tracy. I'm married, Tracy's not. We are co-owners of the property. And we purchased it in 2006 with the intent of my family and me coming to spend time here, renting it during the winter time to the snowbirds that I know are very commonly coming here, and my friend Tracy using it as well. At the same time, we found out that there's the ability to do the Airbnb style rentals. We registered with the city, and at the time that we purchased the home, we received a letter from the management company, which has now changed, but it's the same physical people that are doing the management, that says there are no rental restrictions in Palm Springs Villas 2, period. One-line statement on their letterhead. When we registered the property with the city, that was in 2006, we provided that and the other documents that were required at the time. And we re-registered again in 2017. We paid the fine, not the fine, but the annual fees, and at the time, we did the math and said, no, this really doesn't make a whole lot of sense. I mean, with the
Excuse
cost
me, sir,
structure.
you said 2006.
16 was
16.
what I meant to say, yes.
Okay.
Yeah, 2006 was before all this existed.
All right, all right.
So 2016 and then again in 2017. And then I came and learned even more about all the various rules changes and the restrictions and honestly the struggle that the city is going through to figure out how to deal with this. And we always felt that our one-bedroom condominium that we rent to people on a week-long basis, month-long, or even a couple of months-long basis was really not the main target of the city's rules and regulations. It was really these kind of homes that were having big house parties. And we follow the rules, and I try to follow those rules as well. So we registered in 2018, we sent in the $900 fee. We sent in a copy of the letter that we had received when we purchased the home that said there's no rental restrictions at Palm Springs Villas 2. And that was sent back by the city. We also had to change our insurance policy. We had a different carrier that couldn't do something appropriate that the city required, so we changed our insurance policy. And there were a few other things that we had to attest to, including being within a 1-hour drive, 24 hours a day. At that point, or shortly thereafter, and she laid out the timeline, we received a note from the city that our HOA had sent a letter to the city saying that short-term rentals were not allowed. And I heard, I believe it was Mr. King?
Yes.
Mr. King stated earlier during the prior meeting a couple of things that don't match what I had experienced from going to the actual HOA meetings for the Palm Springs Villa 2. Number one is that there were no rules changes. There was a vote in early 2018 by the association that gave 3 options. The first option was to change the CC&Rs to remove the ability to rent for anything less than 28 days. The second option was to say that there would be no restrictions. And the third was to have no change. The third option is the one that prevailed. There was no change. So there were no changes to the CC&Rs, but the board decided to reinterpret. And there has been since then and remains today a big question about what really is or isn't allowed. there's a bit of a circular logic that's being used by the HOA, and is what it is, but basically they're saying, our HOAs don't say that you're not allowed to use it for hotel purposes, but they use the term transition or transitory, and then they're using the city definition of that to define 28 days. So that was a vote in early 2018. I also noticed that the city didn't answer your question about what the HOA does or doesn't allow. And they were saying, well, they did, and then they didn't, and the HOA never allowed rentals, and that I had somehow registered the property through my own promise that there was no restrictions, and that's not the case. There was, in fact, a letter from the HOA when we purchased the property, and remained until sometime this year when they've then written a letter to the city saying it's not allowed. At that time, we removed all of our short-term advertising, so I thought we had it on Airbnb. That was the place that we had advertised. And we've rented the home for a long-term period, for 1 year at a time. And the tenant moved in about a month ago. I guess that this VRBO advertisement was still up. My partner, whose name is Tracy, did respond. I don't have all of the details. I actually never received this information that you have in front of you. I don't want to dispute that, but what I am here to do is request two things. Number one is that we'd be fined $2,500 for the violation of advertising. We did in fact have a permit and was registered. And then second, I'd like that me personally not be banned in the city. The way that I understand the rules is that if you break the rules, that you personally are banned forever, all future, in the city of Palm Springs. But the way that I've heard it today, in previous cases that I've heard in the last half hour or so, is that the individual unit. Maybe you could advise me on what that means. I'm not sure.
We cannot advise you. You're welcome to consult with members of the staff after the hearing.
Okay. Is there any, because you've said it, Mr. Howard, that you would, there's 1A, 2A, 3A, I assume, for your choices of the motions that you can pass, and it sounds like it would be the unit itself that would be forever banned. Is that accurate, or is that inaccurate? It's the individual. Got it. Okay.
I'm sorry,
The individuals on title are permanently ineligible per the ordinance.
And I should note, I own no other property in Palm Springs other than this one condominium. I have no intention of doing anything today, but I'm 44 years old and I don't know what the future holds. And I'd like to remain a citizen in good standing in the community. So in short, I want to say that we had no intent to deceive or do anything wrong. We've registered with the city for 2 years. The property was allowed when we purchased the property, when we first registered the first year and the second year. The third year registration, which is this year, there's some type of change we're just not doing. It's now rented for 1 year. The city, I don't know what the right term is, I might call it a sting, that kind of tested to see what the owners would respond to. My partner Tracy did apparently respond, but it was never rented or occupied. There were no funds received. So certainly she advertised it, would advertise on the VRBO from the staff reports, and it is what it is. So I again would like to request a reduction in the overall fine and not to be banned personally. Thank you.
Thank you, sir. Questions from the board members? Yes.
Not a question, but and correct me if I'm wrong, but even though you as title owner would be banned from a short-term rental going forward, you're never going to be banned for renting it out for a year. That is not part of the regulations.
I don't know where the regulation actually is.
Well, the regulations state that we're talking about rentals for 28 days and less. That's what the regulation is focused on. For rentals of more than that, certainly a rental of 1 year is not even a subject of this regulation. So you don't have the sort of Hester Prynne mark on you, except for short-term rentals. So renting it for a year is fine going forward.
Yeah, again, it just feels like I personally didn't do it. I'm honestly one of the co-owners of the property, and I'm here taking responsibility for that. Not a comfortable position to be in on this side of the table. But at the same time, I recognize that there are rules, and then I intend to follow them, and that's where we are today.
Any other questions of the appellant? And any rebuttal by the staff?
Yes, Peter King, Assistant City Attorney. I want to put this a little bit maybe by analogy into context. So failing to have the registration certificate is like failing to have a driver's license. It's a big fine. But if you have a driver's license and you get a ticket that goes against your license, it's a smaller fine typically. And so the ordinance seems to be set up that way. Now, I notice on page 27 that my colleague, Mr. Kotkin, and the city manager, this regulation was effective just this March 2018. So it's entirely possible that the appellant slipped through the cracks, if you will, or had a vacation rental certificate before. However, when I go through the documents and somebody that buys a property in a homeowners association is charged with knowing. In fact, they get a copy of this before they close. And this is their CC&Rs, okay? And it's very clear in their CC&Rs that no owner shall lease his unit for transient or hotel purposes. I don't know what vacation rental is if it isn't a transient purpose, as opposed to, as you pointed out, a month-to-month lease or a year lease, month-to-month tenancy or year lease. So they did know that, and he did know this. This is their rules and regulations. By the way, the board, an HOA board, not the entire membership, which is required to change the CC&Rs, these are their operating rules, and the board can change that. They're the representatives of the HOA. And this board decided in 2018 to call out specifically short-term rentals and even cite to Palm Springs Municipal Code saying that you can't do it. So, so what we come back to is what is being cited, and that's simply not having a driver's license or not renewing it. So it's as if you don't have one at all, by analogy. Here, he's being cited for not having registered, period.
Ms. Severin?
I just wanted to note that we did reach out to the HOA regarding the letter, the previous letter that we had, that this gentleman mentions was in the application package, and they did acknowledge in writing that that was their previous HOA or previous management company, and one of the reasons that they're no longer using them is because this particular letter went out in escrow packages. So there was some.
Which letter are you referring to?
The letter that accompanied the original application of the appellant, saying that they could, in fact, have a short-term rental.
So there was a letter to that effect?
There was a letter, and it was from a previous management company. And the board had apparently not sanctioned that letter. That letter wasn't signed, but it was, we did accept it at the time. And I just wanted to acknowledge that we did have a letter in this case.
That was in 16.
Yes, sir. And that's it. Thank you.
Do we have any public comments for this case? No.
No public comment.
Appellant has another.
Do you want to entertain anything further from the appellant?
It looks like he has one more comment to make, so.
I don't have an objection if you want to.
If you want.
Do you want to be heard further?
Yes, sir, I do.
Very briefly.
Absolutely. So I've just heard two people from the city state in very forceful terms and in a tone of voice that I'm somehow not aware of what's in the rules. And then there was a reading of the rules that don't define days, that does lead to some confusion, that does lead to further questions. And at the time that I purchased the home and in subsequent years, I did request that information. Now, I'm sorry, say your name? Suzanne. Ms. Suzanne stated that, oh, there's this letter that he brought up. It's not just some letter. It's literally a letter from the HOA management of the board that I own a property in that says, in one sentence, there are no rental restrictions. We brought that to the city. We brought it to the city again when it was time to re-register. And to say that the HOA management changed because of certain reasons I don't think that that's something that the city actually knows. And I feel that she's making a statement without really understanding the circumstances of the HOA. The actual people, the human beings that are the management company are the same people, but there's a different management company. But to say that they were changed because of a reason, that's the first time I've heard it. And I've attended board meetings of my association now for the last 2.5 years. And that's not been the reason stated at the HOA meetings for the change in the association. So I respect that that's your perspective, but I don't think that the city should be stating why an HOA management board is being changed at a property without true facts.
All right, sir, thank you.
Thank you.
Well, we can do it in our discussion among
All right.
ourselves.
Anything further? You have an opportunity, since we afforded the appellant
I
another
just want to,
opportunity.
I just want to be clear that that wasn't our assumption. That was information that was provided to us from the HOA board. That's all. Thank you.
All right, we had no public comments, and so I believe we're ready to hear from board members. Mr. Cronander.
I'll start this time. Again, I think I'm restating what I said before. I think we're getting, or have gotten, too muddled down in the HOA issue as to what they provided, what the old HOA provided or allowed, what the new HOA allows. We have, you know, as the assistant prosecutor stated, a pretty simple case of, you know, there were certain requirements that the appellant was required to fulfill in order, this time around, let's put aside 2017, 2016. Those are not relevant. Those issues are not relevant. Any letter that was provided at that point is not relevant. To obtain the renewal of his license this time around, he was required to comply with a checklist of items. The failure to comply with any of those items on the checklist would have prevented a renewal of the short-term rental license. So I think we go off on a tangent when we start looking back over HOAs from the past and so on. He did not comply with the present requirements. He was notified that he was not in compliance with the present requirements, and that his check did not provide him any, so to speak, cover for not complying with all of those requirements. And as I think I'm right in saying, you sent the check back. So to me, it's fairly clear that he had no license when he continued to advertise on VRBO.
Thank you, Mr. Cleary.
Yes, thank you very much. I appreciate your comments. I think that the facts of each case are important, and that to just put the blinders on and to see whether or not this particular application checklist was complied with ignores the facts. And the history and the facts in this case show that he was a permitted vacation rental certificate holder, that when he purchased property and created the VRBO account, he was perfectly within the law and had a valid certificate. And then whether or not this, I agree that it's difficult for us to delve into HOA law, but I would wonder what an HOA, if you were advising the HOA and you were the lawyer advising the HOA, what you would say to a board that made regulations contrary to the CCNRs without putting it to a vote of the HOAs. I bet you your advice would have been at that time that that would be an illegal act by the board, and they could not pass a rule or regulation that violated the CCNRs. That's probably what your advice would have been. So I don't want to litigate the CCNR violation, but one way or the other, in this case, what we're doing is the city is giving to this board the power of regulating this individual's rental certificate, because it is up to this board that decides what the meaning of the CCNRs are, and if an HOA wants to ban permanent rentals, they can do so. They can put it to a vote. They can ban temporary rentals, just like the city did, legally. One notice or regulation provided in our packet, which was in effect at the time that this citation was issued, was the CC&R vacation rental administrative procedure that an individual provide a letter from the CC&R, and failure to do so wouldn't subject him to a loss of his permit. He wouldn't be denied a vacation rental certificate. He would a property that rents without failing to provide the VRCO within 30 days, a written notice from the board would be subject to a first violation of $500 or a second violation of $1,000 not to exceed $5,000. That's what the regulation is that was in effect at the time. And it addresses this specific thing, but what the city is advocating is to say, oh, well, look past what this regulation is and how this individual certificate was actually denied, and they just sent his money back, and we're just going to claim that he doesn't have a certificate because the regulation that requires him to provide a certificate from the board, which is having issues regarding whether or not they're going to permit or how they're going to address short-term rentals at their. I mean, I just don't see the city as. I mean, I understand that they wish to take, and I think it's a good idea that they contact HOAs and find out what is the position of the HOA, but it's not to give the HOA the power of the permit. It's not up to them. That's a separate entity. The city has passed a regulation and determined what the regulation, what individuals should do. The city does not say you can rent short-term rentals if your CC&R says so in violation of the ordinance. If the city prohibits the it's still prohibited no matter what the CC&R say or some vacation rental or HOA says. So, I just am struggling with it because I think that the true facts of it, you can't just look at the citation and say, oh, well, we didn't give him a certificate, so therefore he's in violation of $5,000. I mean, he didn't issue a certificate for a number of steps that were required that involved specifically providing proof from the CC&Rs of his HOA.
Not all of them. There were many. For one thing, I heard that an application for renewal was required and not submitted. So forget the whole HOA, CC&R thing. There's a failure of the renewal. And the express communication back to the owner that the renewal has failed, the money's being returned, and then a period of 6 weeks elapses with no action by the owner except to advertise the property and accept an engagement of the property. So I suggest that would ease your struggle if you find those facts as I do. And I don't have any blinders on, so.
No, I don't see any blinders for the record. But I still note that the fee schedule or fine schedule, as indicated by the administrative regulations, cite a different fine. The homeowners presented a proposition that is, much greater than the three-tiered fine schedule that is outlined in the regulation, the administrative regulation. The homeowners suggested that the fine be $2,500. We have, in the past, adjusted fines for various reasons. It's greater than the fine that was in the administrative regulation. It's what the homeowner proposes. I would be of a mind to go with the homeowner's suggestion that he be fined instead of the full $5,000 to $2,500, and I'd make that a motion at the appropriate time.
I just have one thought, and in looking through this regulation, it appears to me that it doesn't apply to fresh renewals or original requests for certification. What it appears to do is refer to an existing registration where the CCNRs have changed. And it states that, they have a compliance period if that CCNR is changed. And it does say that the revocation, not institution of, but revocation of an existing registration certificate does not itself deem the owners ineligible to apply for another registration certificate for the same property. It doesn't really address the renewal of, at least in my looking it over, address a renewal of a registration certificate without the appropriate documentation from the homeowners association. So I'm not clear that this doesn't even apply to our situation. We're talking about a new certificate. So that's my only thought.
I cannot say that I've sat on every case that has been before this board, but I've sat on most of them. I don't recall a case where the board found either a legal basis or any other reason for modifying the penalty imposed for the violation. And I'm not aware of any legal basis on which we have the authority to do that as of today, including reducing the existing fine of $5,000 down to $2,500, and including splitting the violation between two owners and overturning it as to one and upholding it as to the other. I don't know of any authority that would enable us to act in that fashion. Any further discussion? Is there a motion?
I guess once again, I will make a motion to uphold the administrative decision that Adam Breali and Tracy Cambron are permanently eligible to operate a vacation rental at 2821 North Los Feliz, Unit K208, and to uphold the administrative fine of $5,000 issued to the same.
Thank you. Is there a second? I'll second the motion. Roll call.
Board Member Cronander?
Aye.
Vice Chair Howard?
Aye.
Board Member Cleary?
Nay.
Motion passes 2-1.
All right. Thank you, sir.
Board Member, or Vice Chair? No, if I just make a comment, I have a request to speak from Janae Hooker. However, I just want to point out that testimony taken during appeals is specifically to that person's appeal. And then we have a general public comment period, but that's in the beginning of the meeting. So there is no opportunity to speak on general comments at this time. Unless the board wants to use discretion.
When was that submitted?
Just now.
Okay.
You can always decide to take it if you like, but.
Public
This is-
comments specific to each appeal.
She just wants to speak about the appeal process.
Okay, not related to a particular
Correct.
case before us.
Correct.
Okay. All right, we'll move to item 4. This is an appeal of the administrative decision that Renate M. Stallworth is permanently ineligible to operate a vacation rental in the city of Palm Springs, and the administrative fine for operating an unregistered vacation rental property located at 695 South Highland Drive, Palm Springs, California. Staff report.
Thank you, Vice Chair Howard and members of the board. The property located at 695 South Highland Drive in Palm Springs did not hold a vacation rental registration as of the date of the administrative citation issuance on July 23rd, 2018. Staff has determined that the current owner has, without a registration certificate, advertised and operated the property as a vacation rental. Staff is noting that a local agency, Vacation Palm Springs, applied for a vacation rental registration certificate on behalf of the owner of this property and was registered as a vacation rental with Vacation Palm Springs, assisting in the compliance of the vacation rental ordinance requirements, including reporting and remitting transient occupancy taxes for the owner. This continued until Vacation Palm Springs sent a notice to Vacation Rental Compliance Department of a cancellation of the management of the property on May 11th, 2018. The VRCD, Vacation Rental Compliance Department, was advised that the cancellation was taking place since the owner canceled its contract with Vacation Palm Springs for their services. The vacation rental ordinance allows an owner to retain an agent or representative to assist in compliance with the vacation rental chapter, which includes filing of a complete vacation rental registration to register a property, the management of the property, compliance with the requirements of collecting taxes for the city and payable to the city. The section specifically that affects this particular case is located on, it starts on page 2, where section 5.25060, item D, it says vacation rental registration requirements states the following. In the event of a change in agent or the occurrence of any other material fact set forth in the annual registration, a new registration for a vacation rental shall be required to continue operation of the vacation rental, and within 7 days of said change, the owner or his or her exclusive listing agent shall submit the required registration fee. The advertisement of the property on 695 Highland was found by the VRCD department on Airbnb.com under the title Indian Summer, under advertisement number 213-68187. The department's code compliance officer sent an inquiry for 7 nights, and the host responded affirmatively. The ad identifies the owner as Renate Michiko, co-host. That's on page 46 of your packet. The ad shows a 2-night minimum stay. We show 27 reviews of the property, including several of them after May 11th, which was the termination date by the owner as requested in her email to Vacation Palm Springs. We show check-in and check-out times. We have a personalized reply from the host to the inquiry, page 40 and 41 of your packet, and a pre-approval to book the property on page 40. Based on the advertisement information and inquiry into the property being offered as a vacation rental, the City of Palm Springs Vacation Rental Compliance Department proceeded with issuing an administrative citation AB 0175 in amount of $5,000 to the owner on title, Renate Stallworth, and for operating a vacation rental without a vacation rental registration certificate. The administrative citation was mailed to the mailing address on title, and a receipt was confirmed. We do have the code compliance officer who did do the inquiry and did the investigation present for any questions that the board may have. I do not have any questions of him at this time. That concludes the staff report. I'm available to answer any questions because this case is a little bit different than some of our previous cases. Thank you.
Any questions of board members?
Not this time.
What is the, what is the staff's position with regard to the appellant's knowledge of the cancellation of the contract by Vacation Palm Springs?
The individual homeowner on title requested in an email in writing to Vacation Palm Springs that Ms. Ms. Stallworth is terminating their relationship and terminating the managing of the property.
Who said that?
The owner of the property, Ms. Renee Stallworth. It's in an email in your packet.
Okay, where is that?
Give me 1 second. It's on page 32. About 3/4 on the page, there is a sentence that begins, "Well, unfortunately, we have so many misunderstandings and issues. Therefore, I will cancel our contract with Vacation Palm Springs effective immediately." And this email was sent on May 11th, 2018 at 5:41 p.m.
Right. And how did the staff learn of that? The
Staff-
agency notified you?
The agency notified us
Okay.
via what's called a deletion form. They sent us a list of properties that they will be no longer managing, that are no longer associated with their TOT number, that basically those permits are no longer in effect because those homeowners, some of them may choose to go to a different agency, some of them may choose to manage on their own.
And it's your position that section 5.25060D, under those circumstances, requires a,
Correct.
requires what?
A new application for the property. What becomes very important is when property terminates a relation with an agency, we don't have all the information on file for the owner. So for example, when an agency manages a property, they are the local contact in case of any nuisances or issues that arise at the property. By having a new application come in to the city, we get updated information from the homeowner with respect to who the local contact is, where is their mailing addresses, where we can send communication, and in this case, once the homeowner terminated the relationship with their agency, no further communication came into the city relating to this property.
If there's a, if the fee for the registration is paid for
1 year.
a year,
Mhm.
and the termination occurs, say, in the first quarter,
Mhm.
what happens then? Is it,
The homeowner will have the remainder of that term. They will not need to pay an additional $900. We will continue to have their property registered for that fee that they paid. And also, if I may, to your previous question, another reason why a homeowner needs to apply is they no longer have a tax ID number. They don't have a transient occupancy tax. With an agency files on their behalf under the agency transient occupancy tax number, and when that relationship gets terminated, the homeowner does not have a way to file taxes. And if you may recall, it's previous cases where we've had is we are not able to issue a vacation rental permit unless somebody has a transient occupancy tax ID number to be able to file taxes from their bookings.
thank you.
You're welcome.
Any other questions of the staff report?
Is there any thing in here from the agency to the city regarding the cancellation of the permit?
On page 39 is a list of properties that Vacation Palm Springs is informing the city of Palm Springs that they are terminating. For the record, I will note that Vacation Palm Springs did provide us with a copy of an email that the appellant did provide. We do have a copy of an email for our records that is on page 32. We did get that. We did not include it in the packet as it was already being referenced by the appellant. Those are the two communications that we have received from the agency.
Any other questions of the staff report?
So the vacation rental certificate in this case was issued to Vacation Palm Springs and not the homeowner?
That is correct, and it was issued for this particular location. We do have copies of the certificates if you would like. I can pass one around. I believe there is one in your packet, but it is not in its entirety. Would you like us?
What page in the packet is it?
The page in the packet that the certificate was provided by the appellant is on page 18. Would the board like us to introduce the full copy of the certificate for the record?
Sure, let me take a look. Sure.
Okay.
I'll take a look at it.
Anthony, we do not have
It just
to-
looks like this is like a corner screenshot or something like that.
And on the record, I would apologize to city clerk for not making 10 copies.
All right. We'll hear from the appellant. Ms. Stallworth, would you come up here, please?
And I'll note that I do have a signed document indicating her testimony is under penalty of perjury.
Thank you.
Can my daughter come in because she's.
Certainly.
Yeah, with grandkids.
Certainly.
And I made 15 copies. And I'm really surprised about this whole case because I had the permit. I had the permit.
Right.
And I only quit Vacation Palm Springs because I had so many problems with them, lies over lies, and only minus because the gas damaged everything. So I quit that because of that. And Vacation Palm Springs brought the original permit in my house, and my husband got it, and he asked them, "Did you quit the permit?" And he said, "No." So I didn't know what's going on. I'm really totally surprised because I paid $900 and they said the permit is on the house, not on the Vacation Palm Springs. They don't own this permit. Only it's because of the house, and it was 2017 and renew for 2018. And so I'm totally depressed about that case because I did nothing wrong. Maybe I missed. My husband came in and asked, "What do I have to do?" And they said, "Oh, that's fine, you have the permit." And Vacation Palm Springs, I didn't know that they do Airbnb as well. So, and my husband wanted to do this rental because we made only minus with Vacation Palm Springs. So, it's my daughter because she's better in English. I'm from Germany, she's too, but she lives longer than me here. And I'm really, I can't get it because in Germany you get a warning or something like that, but nothing, only the one letter. I have to pay 5,000 and I will never get the permit again. So I don't know what's going on here. And really, I know Vacation Palm Springs owns 500 houses, and they're, I guess, a perfect relationship to Palm Springs because it's obviously, but they didn't say to me that they will cancel. They didn't have the allowance to cancel it, not at all. They didn't say one thing, they quit. Nothing. And they didn't say they own the permit. They said, it's my permit, I have to pay it,
I did it and it's on the house. So I don't know why this was a problem. And I went also to a tax manager, and he said he will do everything after this year because I don't have to pay anything. I made so much minus, so I really don't know.
All right, do you have any other information for us?
Pardon?
Do you have any other information to give the board? Anything else you want to say?
Tracy? Ja, vielleicht nicht. Nur, dass ich... No, not in the moment, thank
All
you.
right, thank you.
They went to the house and gave it to my husband, and they said they didn't cancel it. So I have no idea.
All right, does the board have questions for the appellant?
Sure, I just want to make sure I have everything that you wanted us to consider. The first was the copy of the certificate. Well, I'll accept it's a
Yeah.
copy of the
Yeah,
original.
it's a copy.
Okay. And then your notice that your appeal, which we did get a copy of and reviewed, and that your defense basic claim is that you had paid for the entire year, and that the certificate was canceled without your knowledge.
Yeah, right.
And you explained that in your letter, which we got a copy of. And then there was some emails between you and Vacation Palm Springs that kind of explained the miscommunications and bad
Yeah.
relationship you had with them.
Yeah, I had always damages, and they steal so many things, and I have really big issues with them.
Did they send you an email when they canceled the permit to say, thank you for firing us, or our relationship is over?
No.
And your permit is been rescinded or
No.
Canceled or?
No, nothing. Then I would ask somebody what I have to do.
Okay. Anything else you want us to consider?
Jesse, hast du noch was zu sagen? Du kannst ja mal reden. Vielleicht können sie dich besser verstehen.
Can you change? She's thinking maybe I can explain the situation better.
Just a moment, please.
You have to sign a form if you're going to say something.
Okay.
It's an oath that you're
Oh,
testifying
Just
to.
need you to sign it.
okay.
It's just saying that you're doing this under penalty of perjury.
Just
Right
her
here.
name or just a signature?
Yeah.
Okay.
Thank you.
Thank you. Well, I didn't hear everything she said.
What is
so-
your name, please?
Jessica New, N-E-W.
Jessica what?
N-E-W, New.
New.
Yes.
All right.
She actually explained herself very well for her.
Okay.
Her English was actually quite sufficient.
Okay, good. Yeah, but I can attest to that she never received any information that they would cancel the contract or that there's even such a thing. It never showed in the contract between my mom and Vacation Palm Springs. It never said anywhere in there. It said that they would act on her behalf, but not that they could actually cancel it. I mean, how would we know if this was actually purchased for a whole year in advance? So yeah, she didn't know it was not in effect, and just acted in good faith that she was doing the right thing, and yeah, if she had known that it was canceled, she would have done something about it, but she didn't know, and she never received some kind of a warning or something that she's doing this without permission, because if that was the case, she would have gone to city and asked why it was without permission. Because she knew, or she thought, the house itself was, had a permit to be renting the house, short-term. And, yeah, so.
We've been provided with what's represented to be a letter from the appellant to Vacation Palm Springs, where the owner is notifying Vacation Palm Springs that the agreement is terminated.
The agreement between Vacation Palm Springs and her.
Yes.
Yes, because she didn't want to be a customer of theirs anymore because they did nothing for her. All she did was lose money with them, and she was trying to make money as an income.
It sounds like I'm hearing the point that the contract was canceled without the appellant knowing about it. The appellant's the one who canceled the contract.
Right, the contract between her and Vacation Palm Springs.
What other contract are we talking about?
The permit to rent out
All right.
her house.
So
Right,
it's two different things.
right. Yeah, she canceled, I think, in May.
Yes.
Because she kept asking them, please rent out my house, please do something, because I'm depending on this
But
money.
the ordinance, upon the occurrence of that act, the ordinance requires a new registration.
Well, she never knew about that. How was she supposed to know if she purchased this whole permit for a whole year?
Yeah.
She didn't know she had to, because they set that up for her, and she had to sign it, that she would,
Right, so you.
and pay for it.
You have apparently a dispute between somebody who hired somebody to do something,
Right.
typically called an agency.
Mm-hmm.
The principal is dissatisfied with the work of the agent, and there's some dispute between the two of them.
Right.
And that's resulted in this alleged violation. That's
Right.
why we're here today.
Yeah. But, well, like I said, they never notified her that she would lose her permit that she purchased herself in advance for a whole year. So she thought this house itself.
That's what the ordinance provides.
Okay. What exactly is that?
I have a question maybe you can answer. When the check for the whole year came into you, was it a check from Vacation Palm Springs, or was it a check from the appellant?
It was a check from Vacation Palm Springs. Actually, correction, it was from Wyndham Corporate Headquarters, which is the parent company of Vacation Palm Springs, payable to the city of Palm Springs in the amount of $900. Thank you.
Which then later on, or ahead of time, I'm not sure, they deducted from her.
Right,
pay.
she reimbursed.
Yes.
But
She had to pay for it.
But she
Right.
paid Vacation Palm Springs,
Yes.
not the city.
Right, but she still had to sign for the permit with the city. She had to sign for it. They didn't sign. She had to sign.
All right.
You wanted to say something?
I was just going to clarify, the owner does have to sign the application because the owner is responsible even though they have an agency assigned. It doesn't relieve the owner from any obligation, so the owner does sign the application, but the application is submitted by the agency on behalf of the owner, and they let us know that they are the representing agency. But the owner does have to sign on the application itself.
Do we have a copy of the application in our packet?
You do not. I do have one present if you would like to review it, if that's something you would like. The city didn't think that it was necessary, but we were happy to provide a copy at this time. Is this something that the board would like to see?
I'd like to see it, yeah.
Thank you.
Ms. New, thank you.
You're welcome. Any questions? Okay. Thank you for letting me speak.
Very well.
Do we have any public comments?
No public comment?
Mr. Vice Chairman, is this an appropriate time for the city to make additional comments after testimony? Or would you like us to hold off until further review of the
You
application?
can proceed.
Okay, thank you. I do have to echo my partner, Ms. Severin, the section of the municipal code 5.25050 under agency, sections title agency, does say that owner of the vacation rental shall execute all application and documents requirements as provided in this chapter and shall remain responsible for compliance with the provisions of this chapter. The failure of an agent to comply with this chapter shall not relieve the owner of the owner's obligation under the provisions of this chapter. And based on that section, we acted on the owner executing the application and the owner being ultimately responsible still for the compliance of the chapter. I do want to make note that through communication with Ms. Stallworth that we were made aware that her husband operated a vacation rental property, and there are 5 guest stay reviews since May through July, and the city's concern is how and if those taxes were paid to the city for those 5 guest stays, since a TOT number was not issued to the homeowner of that property. That concludes the city's comments. Thank you.
All right. All right, board members, comments for deliberation, motions, disposition?
If I might, I think it really comes down to just the appellant's lack of awareness of section 525.060D, that she was required once the agency ended to put the registration, I guess, in her own name, because she wouldn't have to pay an additional $900. But that was her obligation to get would she have gotten it transferred over to her own name, or what's the mechanic of that?
Correct. The mechanic would have been that upon contacting our office, the homeowner would have been guided to either submit a new application as a owner-operator, or if they chose to go with another agency, the department would have guided them, given them all the necessary paperwork, and they would have been processed based on the complete application. And we would have been issued, and they would have been issued their own tax ID number. There wouldn't have been any issues from what we can see at this time.
I see. Thank you.
Mr. Cleary?
Well, I'll just note that the application does have the homeowner's contact information, name. It appears to have a signature of the agent under the agent information, and then it has a signature under the owner signature. And then the owner signs an additional, the regulations, the owner signs some additional forms regarding insurance and individual information like that, and includes a copy of their driver's license. So it appears that the owner is required to review and sign the application and declares under penalty of perjury the truth of all the information contained therein. It seems a little unusual, I think, that the city requires the permit holder to sign an exclusivity agreement with the agency that they are a hire, and the homeowner actually has to agree that the agency that is submitting the application for the permit is their exclusive agency, and that no one else can rent it, including the homeowner, even if it's the homeowner's permit. So that's in there, that they're agreeing to the exclusivity of that agency to that agency. So it's not. It appears that although it may be the homeowner's permit, that permit is based on an exclusivity, meaning that only that agency can rent for that homeowner. That's what it says, and that's what you signed. And so you don't own the permit in the sense that you think of you own the permit. they own the permit, it seems to me, on the exclusivity agreement, which is a little unusual, but it's there.
But they say the difference.
Excuse me. Thank you.
Okay, so, so it does appear that there is, your hands are kind of tied as to who manages, arranges and everything else, your rentals, as per your agreement. Maybe in the city in the future would, having the ability, having the homeowner's email, you could notice the homeowner out of a courtesy that, hey, your permit's terminated. You're getting notice from the agency agreement. This was a dispute between the agency and the homeowner, but an email to all parties, including the owner party, that your agency is hereby terminated, or your permit is hereby terminated, would at least relieve the city of any knowledge defense that may be brought later at a hearing such as this. That would be the conclusion of my comments. And we did have a copy of this that you provided, Mr. Stark. She provided a copy in her exhibits as well, so the copy of the actual certificate. Yeah. So I'll hand it back to him.
Okay. All right. Is there a motion?
I will offer up a motion.
Busy guy today.
What's that? I would offer a resolution upholding the administrative decision that Renette M. Stallworth is permanently ineligible to operate a vacation rental in the city of Palm Springs. It's including the property located at 695 South Highland Drive. That is 2A and 3A. We would uphold the administrative fine of $5,000 issued to the same.
Thank you. Is there a second?
I'll second.
It's been moved and seconded. Roll call?
Board Member Cronander?
Aye.
Board Member Cleary?
Aye.
Vice Chair Howard?
Aye.
Motion passes 3-0.
Thank you. Item 5 is under other business, approval of minutes, specifically a special meeting of July 18th, 2018. Any discussion? Is there a motion?
I was absent for that meeting. So.
I can make a motion that we adopt the minutes of the July 18th special meeting.
And I will second the motion. All those in favor? Aye.
Aye.
Are you abstaining?
I wasn't there, so.
You can still vote.
Oh, then aye.
Item 6, board member comments and requests. I have none. Mr. Clary?
I did want to bring up the issue that Mr. Kearns, I think, was it Mr. Kearns that submitted a letter?
Resignation.
Are we going to address that? I think he wanted the email memorialized.
I can certainly do that.
He just wanted to know that he's resigning.
Board members, city officials, staff, and fellow residents, I respectfully request that this email be read at the next Administrative Appeals Board hearing and be made readily available to the public. It has been a great pleasure being part of the Administrative Appeals Board for the last almost 3 years. I've enjoyed my time on the board and have worked with some great people, staff, and officials in the city. However, unfortunately, due to the inability of the city to accommodate the official deployments with the federal government I am ordered to be on, I'm left with no available choice other than to issue my resignation from the Administrative Appeals Board effective immediately. Board, city officials, and staff, if you have any questions regarding this, feel free to contact me.
All right. Thank you. Anything else, Mr. Clary?
Not at this time, thank you.
Mr. Cronander?
Nothing, thank you.
All right. Number 7 is city prosecutors' reports and comments. Mr. King is indicating none.
We have no comments.
Number 8 is the city clerk's reports and future meeting dates.
You have a meeting. You have a meeting scheduled for September 12th. That will be approximately 4 or 5 cases. And then an all-day session on Friday, September 21st. I do have a question on how many cases you would like to hear that day.
What day of the week is the 21st?
That would be a Friday.
Friday.
And that will, we can either do 8 or 10.
Wasn't that an all-day one? Is that what
That's
you're?
the all day. How long do you want to go? I can stay all night if you want.
Okay, wait. So, is this a date that you pitched to us already?
Yes.
And you have a quorum?
All of you are available. Mr. Cronander will just be arriving a little late.
Okay, so that's a Friday.
Correct.
And now, what's your question?
Do you want to hear 8 cases or 10?
Well, we just heard 4 in about 2.5 hours. So, what's your pleasure, board members?
I can go late, I just can't join you until early afternoon.
I think that, was the lower number 8? I think that would be very ambitious.
That's, I agree, yeah, I think that's.
Okay. I don't want to burn you out.
All right.
Thank you.
And that's all my comments.
All right. So the adjournment would be to Wednesday, September 12th. And what time is that?
3:30.
3:30. And you have a quorum for that?
Yes.
Okay. And so is there a motion to so adjourn? I'll move to so adjourn.
I'll second that motion.
All right, all those in favor? Aye.
I.
Aye.
Thank you, everyone.